All right, ma'am, you are Catherine Castillo.
Yes, ma'am.
And so Ms. Castillo was previously in court, entered a plea of guilty to driving while intoxicated third or more in 24 DCCR 2458. There was a new offense. We were waiting on the labs. It looks like we've all received those labs at this point. And so what is the state?
Called Rose PD last week on the 30th. I got in touch with the detective. He was going to have it to us by this week, and that'll give us a chance to get into grand jury.
Okay.
So just reset it one more time. I think we can get it.
And I will say this, Your Honor,
Okay.
everything's been evaluated on my end. We have been in communications. I have the PSI, reviewed all the evidence. We're ready to move forward, so we can get on the docket or...
We'll just do a normal reset about 30 days. That'll give you time to get that case indicted, for you to get all of the discovery on that case. And then whatever, if there's an adjustment because of that to the plea or the negotiations, obviously it's concerning. So I'm not sure where the state is. So you guys talk and we'll see where we are at the next court date. Stay in touch with Mr. Pageant so that when he gets all of the discovery for the new case, you guys can go over that. He'll talk with Mr. Smith, and so we'll get an announcement and see where we are at that next court date.
And I do have the blood work as well on the new case, so your staff was napping, got it to me quick.
Perfect. Thank you. Y'all are free to go.
Your Honor,
Yes.
Ms. Hilaire that we had on the designation docket, we're gonna need to reset it. I mean, I guess a couple of weeks, because she already has the money. She said she's gonna get a cashier's check too.
Let's just reset it 1 week.
Okay.
Even this defendant's
Hang on just a second. Good morning. You're Carly Davis. Could everyone please hold it down? So Ms. Davis, you were late for court. I forfeited those bonds. I'll recall those forfeitures. It is extremely important that you are on time to court. Do you understand?
Yes, ma'am.
And so your cases are set for trial to begin with jury selection next week. Is everyone ready?
Your Honor, I think that my client has something she'd like to request of you.
Judge, before we get to that, given this defendant's recent violations of the drug patch, I'd ask that she be drug tested today.
So the drug patch, I have prescription. We've been we've been doing that. We got the prescription. It's the same one. There's nothing different. Otherwise, I would absolutely agree with you. So you're not driving, correct? Right. So that was part of that agreement. And so what do you have to say?
With all due respect, I have, after our last time in front of you in February, I had signed a plea rejection, and it was recently she told me the offer right before we came in here that morning. And you asked if I had signed a plea rejection on the tablet. She stated no, so we went in the hallway and signed it. That plea rejection was different than the one that she had offered me right as we were at the elevator. So I was a little confused, and it didn't click until we were already, it was over. I was still here waiting for my Uber, and I sent her a text, and I never heard anything back. And I've tried to call several times. She finally had texted me about a month later and said she had been out. She would call me the next day. And I can show records where I've been trying to get a hold of her. And
So Your Honor, I just have my phone records.
Well, yeah, it could have been 30 days. I mean, there's not all that adds up because it's only been 30 days since your last court date. Here's the thing. I just need to know if we're going to trial or not. If you want to take a plea offer, then you guys can discuss that this morning and we can get it taken care of. But your case is set for trial next week. I'm not changing attorneys. I'm not setting it for anything. I will order the cases for trial tomorrow after my jail docket. And so you will know then what the trial order is for next week. But after today, there won't be any plea agreements accepted. Do you understand that? Yes. So do y'all want to visit for a minute, or do you want to go forward with trial?
Probably.
Visit for a minute? Okay, I'll hold it. Y'all go visit. Thank you.
Thank you, Sam. Follow beyond this is Corey Anderson. We did rejections.
Okay. I'm going to need you guys to sign that, please. Good morning. Are you Kaylin Billups?
Yes, ma'am.
And this is cause number 19-32315. Ms. Phillips was previously in court on probation for a deferred probation for aggravated assault with a deadly weapon. And There's a motion to revoke. We were previously here and she entered pleas of true to counts 1, 2, 4, and 5 in that motion. And I've received the updated report. Have you both had an opportunity to review that report?
Yes, sir. Yes, sir, we have. And after speaking with probation and Mr. Kimler, I think we have an agreement
Okay,
to follow the
recommendation.
recommendation of safe fee. That's correct, Your Honor.
Okay, so,
We need to resolve the misdemeanor, which hopefully I can do that this morning.
all right, Ms. Phillips, in cause 19-32315, I'm going to find that you entered your pleas of true to counts 1, 2, 4, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation. However, probation has made a recommendation, and it sounds like everyone is willing to work with you to give you an opportunity to be successful. And so I'm going to go along with that recommendation and continue you on probation. Order that as a condition of your probation, you enter and successfully complete the SAFE-P program, the special needs SAFE-P. That will give you the treatments you need, hopefully, for everything going on, mental health, drug abuse, whatever it is, so that when you get out, you can be successful and you'll have the tools to be successful. It's important that you do everything you're supposed to, make the best out of that treatment. When you get out, you will have aftercare that will also be a condition of your probation. So it's important that you do all of that as well. Do you understand?
Yes.
If not, and you violate again, I can assure you, if you're back in here on another motion, things will not be this easy. Do you understand?
I understand.
Okay. This was not an agreement. You do have some limited rights to appeal. Mr. Kimler will hand that to you. I wish you the best of luck, ma'am. You can go back with the bailiff, and thank you, ma'am, for being here on probation.
Thank you.
Mr. Kimler?
Yes, I'm sorry.
Good morning, sir. Are you Jorge Del Fiero? And Mr. Del Fiero, in cause number 25, DCCR 0892, you're charged with third-degree felony offense of assault family violence by impeding breath or circulation from January 31st of 2025. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 10 years in prison. Do you understand?
Yes.
And I have here on the tablet a plea bargain rejection that you've signed with Mr. Kimler.
Yeah.
This shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a 5-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation, including a no contact with the complaining witness. You understand?
Yes.
You have every right to reject that offer and go to trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, sir.
And do you want to reject that offer and have your case set for trial? All right, we'll get that done. And Ms. French, is there any reason to believe that that offer would change in any way?
It's gone now.
Okay.
Just to be clear, Your Honor, it's a condition of his bond. There is a no contact with the victim. Is that correct?
There should be.
Yeah. Contact. All right.
Yeah, so it's important that if it isn't already, I'm sure it is, a condition of your bond is that you have absolutely no contact or communication with Amelia Adams.
Yes, ma'am.
That obviously means in-person contact, but it also means sending messages through other people or social media or anything like that.
To be sure a child knows, so there has to be some internet communication or visitation.
So there are apps you can use, like the Family Wizard, where you don't have to have actual contact, but you communicate through an app that saves everything. It kind of protects both of you so that all communication is saved on that app. It shows it's only about what's going on with the child, pick up, drop off, school stuff, whatever it is. My suggestion would be that you use that, unless you have some third party, a parent or grandparent or somebody to help. But it's a nice thing to use anyway, really just to protect yourself so that you are, and it's kind of handy, you know everything that's going on with the child. If you have something, you can put it on that. If she has something that's going on, she can put it on that so you can both see what's happening with your child, doctor's appointments, things like that.
So to be clear, our communication via the app is not a violation of the bond condition.
Correct, as long as it is only about the child. Now, if you're on that app and you send something that is not about the child, it's saved and we're going to know about it. So that's the best way, and the way that I would definitely approve for you to have contact only with regard to the child.
Yes, ma'am.
Okay. I do want to make sure you understand that after today, I will not accept this plea agreement. It sounds like it's off the table. So if you change your mind later and want to enter a plea of guilty, it would either be open to the court or to some other agreement. You understand?
Yes.
Okay, we'll see you back at trial then. Stay in touch with Mr. Kimler.
You got this good?
All right, Ms. Woodruff, and cause number 26, DCCR 0034, you're charged with the state jail felony offense of possession of a controlled substance, and that's from March 2nd of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablets some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kindler?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is for a 4-year deferred probation. There would not be a fine. You would be required to follow all of the rules and conditions of probation. This would run concurrently. It looks like you're already on probation for cause numbers 24 DCCR 1710 and 25 DCCR 0426. And I'm guessing that's just because this was
It preceded
those because of.
Yes, ma'am.
This is one of those courtroom moments that sounds simple, but carries enormous consequences. The defendant has just rejected a plea offer, and the prosecutor makes it crystal clear that deal is officially gone. Once a plea offer disappears, there's no guarantee it ever comes back, and that's a gamble every defendant has to weigh carefully. What's fascinating is how often we see this tension in court. Take the certainty of a negotiated outcome, or risk everything at trial, hoping for a better result.
Yes, ma'am.
Is that your understanding of your agreement?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No, Judge.
It's admitted. Is there any evidence that Ms. Woodruff is not competent?
Understand.
And because she's already on probation and this is a state jail and
No,
everything.
no, wait, yes, I do.
All right. So, Ms. Woodruff, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea. I'm going to waive the pre-sentence report, find sufficient evidence to find you guilty, but I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 4 years. You're ordered to follow all of the rules and conditions of probation. And if you do that, again, this is an excellent opportunity. You do not have the felony conviction on your record. Obviously, if you violate any condition of probation, you'll be back in here on this case and the others.